Preliminary. In these regulations, unless the context otherwise requires, a. expressions defined in the Companies Act, 1994, shall have the meanings so defined, and b. words importing the singular shall include the plural, and vice versa, and c. words importing the masculine gender shall include females, and words importing persons shall include bodies corporate. Business. The directors shall comply with the restrictions on the commencement of business imposed by Section 150 of the Companies Act 1994, if, and as far as, those restrictions are binding upon the company. Shares. Subject to the provisions, if any, in that behalf of the Memorandum of Association of the company, and without prejudice to any special rights previously conferred on the holders of existing shares in the company, any share in the company may be issued with such preferred, deferred or other special rights, or such restrictions, whether in regard dividend, voting, return of share capital, or otherwise, as the company may from time to time by special resolution determine, and any preference share may with the sanction of a special resolution be issued on the terms that it is or at the option of the company is liable to be redeemed. If at any time the share capital is divided into different classes of shares, the rights attached to any class, unless otherwise provided by the terms of issue of the shares of that class, may, subject to the provisions of Section 71 of the Companies Act 1994, be varied with the consent in writing of the holders of 3/4 of the issued shares of that class, or with the sanction of an extraordinary resolution passed at a separate general meeting of the holders of the shares of the class. To every such separate general meeting the provisions of these regulations relating to general meetings shall mutatis mutandis apply, but so that the necessary quorum shall be 2 persons at least holding or representing by proxy 1/3 of the issued shares of the class. No share shall be offered to the public for subscription except upon the terms that the amount payable on application shall be at least 5% of the nominal amount of the share, and the directors shall, as regards an allotment of shares, duly comply with such of the provisions of Sections 148 and 151 of the Companies Act, 1994, as may be applicable thereto. Every person whose name is entered as a member in the Register of Members shall, without payment, be entitled to a certificate under the common seal of the company specifying the share or shares held by him and the amount paid up thereon. Provided that, in respect of a share or shares held jointly by several persons, the company shall not be bound to issue more than one certificate, and delivery of a certificate for a share to one of several joint holders shall be sufficient delivery to all. If a share certificate is defaced, lost, or destroyed, it may be renewed on payment of such fee, if any, not exceeding 5 taka, and on such terms, if any, as to evidence and indemnity as the directors think fit. Except to the extent allowed by Section 58 of the Companies Act 1994, no part of the funds of the company shall be employed in the purchase of, or in loans upon the security of, the company's shares. Lien. The company shall have a lien on every share, not being a fully paid share, for all monies, whether presently payable or not, called or payable at a fixed time in respect of that share, and the company shall also have a lien on all shares, other than fully paid shares, standing registered in the name of a single person, for all monies presently payable by him or his estate to the company, but the directors may at any time declare any share to be wholly or in part exempt from the provisions of this clause. The company's lien, if any, on a share shall extend to all dividends payable thereon. The company may sell, in such manner as the director thinks fit, any shares on which the company has a lien, but no sale shall be made unless some sum in respect of which the lien exists is presently payable, nor until the expiration of 14 days after a notice in writing stating and demanding payment of such part of amount in respect of which the lien exists as is presently payable, has been given to the registered holder for the time being of the share, or the person entitled by reason of his death or insolvency to the share. The proceeds of the sale shall be applied in payment of such part of the amount in respect of which the lien exists as in presently payable, and the residue shall, subject to a like lien for sums not presently payable as existed upon the shares prior to the sale, be paid to the person entitled to the shares at the date of the sale. The purchaser shall be registered as the holder of the shares, and he shall not be bound to see to the application of the purchase money, nor shall his title to the shares be affected by any irregularity or invalidity in the proceedings in reference to the sale. Calls on shares. The directors may from time to time make calls upon the members in respect of any monies unpaid on their shares, provided that no call shall exceed 1/4 of the nominal amount of the share, or be payable at less than 1 month from the last call, and each member shall, subject to receiving at least 14 days' notice specifying the time or times of payments, pay to the company at the time or times so specified the amount called on his shares. The joint holders of a share shall be jointly and severally liable to pay all calls in respect thereof. If a sum called in respect of a share is not paid before or on the day appointed for payment thereof, the person from whom the sum is due shall pay interest upon the sum at the rate of 5%. Per annum from the day appointed for the payment thereof to the time of the actual payment, but the directors shall be at liberty to waive payment of that interest wholly or in part. The provisions of these regulations as to payment of interest shall apply in the case of non-payment of any sum which, by the terms of issue of a share, becomes payable, at a fixed time, whether on account of the amount of the share, or by way of premium. The directors may make arrangements on the issue of shares for a difference between the holders in the amount of calls to be paid and in the times of payment. The directors may, if they think fit, receive from any member willing to advance the same all or any part of the monies uncalled and unpaid upon any shares held by him, and upon all or any of the monies so advanced may, until the same would, but for such advance, become presently payable, pay interest at such rate, not exceeding, without the sanction of the company in general meeting, 6%, as may be agreed upon between the member paying the sum in advance and the directors. Forfeiture of shares. If a member fails to pay any call or installment of a call on the day appointed for payment thereof, the directors may, at any time thereafter during such time as any part of such call or installment remain unpaid, serve a notice on him requiring payment of so much of the call or installment as is unpaid, together with any interest which may have accrued. The notice shall name a further day, not earlier than the expiration of 14 days, from the date of the notice, on or before which the payment required by the notice is to be made, and shall state that, in the event of non-payment at or before the time appointed, the shares in respect of which the call was made will be liable to be forfeited. If the requirements of any such notice as aforesaid are not complied with, any share in respect of which the notice has been given may at any time thereafter, before the payment required by the notice has been made, be forfeited by a resolution of the directors to that effect. A forfeited share may be sold or otherwise disposed of on such terms and in such manner as the directors think fit, and at any time before a sale or disposition, the forfeiture may be cancelled on such terms as the directors think fit. A person whose share have been forfeited shall cease to be a member in respect of the forfeited shares, but shall, notwithstanding, remain liable to pay to the company all monies which, at the date of forfeiture, were presently payable by him to the company in respect of the shares, but his liability shall cease if and when the company received payment in full of the nominal amount of the shares. A duly verified declaration in writing that the declarant is a director of the company has been duly forfeited on a date stated in the declaration, shall be conclusive evidence of the facts therein stated as against all persons claiming to be entitled to the share, and that declaration, and the receipt of the company for the consideration, if any, given for the share on the sale or disposition thereof, shall constitute a good title to the share, and the person to whom the share is sold or disposed of shall be registered as the holder of the share and shall not be bound to see to the application of the purchase money, if any, nor shall his title to the share be affected by any irregularity or invalidity in the proceedings in reference to the forfeiture, sale, or disposal of the share. The provisions of these regulations as to forfeiture shall apply in the case of non-payment of any sum which, by the terms of issue of a share, becomes payable at a fixed time, whether on account of the amount of the share, or by way of premium, as if the same had been payable by virtue of a call duly made and notified. Conversion of shares into stock. The directors may, with the sanction of the company previously given in general meeting, convert any paid-up shares into stock, and may with the like sanction reconvert any stock into paid-up shares of any denomination. The holders of stock may transfer the same, or part thereof, in the same manner, and subject to the same regulations, as in subject to which, the shares from which the stock arose might previously to conversion have been transferred, or as near thereto as circumstances admit, but the directors may from time to time fix the minimum amount of stock transferable, and restrict or forbid the transfer of fractions of that minimum, but the minimum shall not exceed the nominal amount of the shares from which the stock arose, and may also prohibit or restrict the transfer of such stock. The holders of stock shall, according to the amount of the stock held by them, have the same rights, privileges and advantages as regards dividends, voting at meetings of the company, and other matter, as if they held the shares from which the stock arose, but no such privilege or advantage, except participation in the dividends and profits of the company, shall be conferred by any such aliquot part of stock as would not, if existing in shares, have conferred that privilege or advantage. Such of the regulations of the company, other than those relating to share warrants, as are applicable to paid-up shares shall apply to stock, and the words share and shareholder therein shall include stock and stockholder. Share warrants. The company may issue share warrants, and accordingly the directors may in their discretion, with respect to any share which is fully paid up, on application in writing signed by the person registered as holder of the share, and authenticated by such evidence, if any, as the directors may from time to time require as to the identity of the person signing the request, and on receiving the certificate, if any, of the share, and the amount of the stamp duty on the warrant and such fee as the directors may from time to time require, issue under the company's seal a warrant, duly stamped, stating that the bearer of the warrant is entitled to the shares therein specified and may provide by coupons or otherwise for the payment of dividends, or other monies, on the shares included in the warrant. A share warrant shall entitle the bearer to the shares included in it, and the share shall be transferred by the delivery of the share warrant, and the provisions of the regulations of the company with respect of transfer and transmission of shares shall not apply thereto. The bearer of a share warrant shall, on surrender of the warrant to the company for cancellation, and on payment of such sum as the directors may from time to time prescribe, be entitled to have his name entered as a member in the register of members in respect of the shares included in the warrant. The bearer of a share warrant may at any time deposit the warrant at the office of the company, and so long as the warrant remains so deposited, the depositor shall have the same right of signing a requisition for calling a meeting of the company, and of attending and voting and exercising the other privileges of a member at any meeting held after the expiration of 2 clear days from the time of deposit, as if his name were inserted in the register of members as the holder of the shares included in the deposited warrant. Not more than one person shall be recognized as depositor of the share warrant. The company shall, on 2 days' written notice, return the deposited share warrant to the depositor. Subject as herein otherwise expressly provided, no person shall, as bearer of a share warrant, sign a requisition for calling a meeting of the company, or attend, or vote or exercise any other privilege of a member at a meeting of the company, or be entitled to receive any notices from the company. But the bearer of a share warrant shall be entitled in all other respects to the same privileges and advantages as if he were named in the register of members as the holder of the shares included in the warrant, and he shall be a member of the company. The directors may, from time to time, make rules as to the terms on which, if they shall think fit, a new share warrant or coupon may be issued by way of renewal in case of defacement, loss, or destruction. Alteration of capital. The directors may, with the sanction of the company in general meeting, increase the share capital by such sum, to be divided into shares of such amount, as the resolution shall prescribe. Subject to any direction to the contrary that may be given by the resolution sanctioning the increase of share capital, all new shares shall, before issue, be offered to such persons as at the date of the offer are entitled to receive notices from the company of general meetings in proportion, as nearly as the circumstances admit, to the amount of the existing shares to which they are entitled. The offer shall be made by notice specifying the number or shares offered and limiting a time within which the offer, if not accepted, will be deemed to be declined, and after the expiration of that time, or on the receipt of an intimation from the person to whom the offer is made that he declines to accept the shares offered, the directors may dispose of the same in such manner as they think most beneficial to the company. The directors may likewise so dispose of any new shares which, by reason of the ratio which the new shares bear to shares held by persons entitled to an offer of new shares, cannot, in the opinion of the directors, be conveniently offered. Under this article, the new shares shall be subject to the same provisions with reference to the payment of calls, lien, transfer, transmission, and forfeiture and otherwise as the shares in the original share capital. The company may, by ordinary resolution, consolidate and divide its share capital into shares of larger amount than its existing shares. By subdivision of its existing shares or any of them, divide the whole or any part of its share capital into shares of smaller amount than is fixed by the Memorandum of Association, subject, nevertheless, to the provisions of paragraph D of subsection 1 of Section 53 of the Companies Act 1994. Cancel any shares which, at the date of the passing of the resolution, have not been taken or agreed to be taken by any person. B. The company may, by special resolution, reduce its share capital in any manner and with, and subject to any incident authorized and consent required, by law.